Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us which really took our fancy and interest. It's an area which I'm not particularly knowledgeable on, and I'm sure a lot of practising barristers certainly are not, but it was one that intrigued me. It's called the Oxford Handbook of Roman Law and Society. There's a certain, very limited influence, of course, from Scotland, but it's always useful to have a much wider picture of how legal systems operate, and we thought this would be an excellent book to review, hence the fact that I'm now reviewing it. Elizabeth and I talked about the book, and we thought it was a marvellous book. No question about that. And we gave for our review title, Roman Law and the Wider World, New Perspectives and Approaches. I've given it another title which is rather more interesting, and that is that I say later in the book, I've said that one of the most important things is that legions, you might say, of fascinating insights are contained in the book. I put that as the front because I couldn't resist it, but that really is the selling point, if I can put it that way. Let's have a look at the book first of all. It's been written by a number of people: Paul J. Plessis, Clifford Ando and Caius Jury. You can see their names on the front there. That's the front of the book. It's a hardback. There's the spine, and then there's a bag. A lot of contributors, far too many for our last to mention. You've got a little inside flap or for the dust sheet, and you've got some information at the front as well about the book. There's a lot of detail. It's a very well written book, of course, from OUP, Oxford University Press. There's quite an interesting index at the back. The structure's slightly different because it shows you the names of the various people, institutes, the digester and so forth. So it's called Index Locorum, which I'm sure will be very interesting for a lot of people. Then there's another index after that, which is on page numbers. And after that, again, the index is quite substantial. You can see there. It explains how the indexes are structured, because then you've got a lot of bibliography at the end of each of the chapters. And of course, you've got quite a lot of footnoting, which is quite important. Now, going to the front of the book, there's the front cover, Oxford Handbook of Roman Law and Society, some acknowledgements and the usual blurb there. Then the structure in parts. You can see there's an introduction. Then from the introduction, it runs through the various parts, and you've got all the information you're looking for in the various parts. And then we have a list of abbreviations, very helpful in this particular area of law. Then you've got the list of contributors, a huge number of people involved in this book. I'd like to thank them all. I can't go through all the names, but you can see the very large number of people involved. Then you get a note on terms and translations, which is very helpful. Then you get a word from the editors, just to set things. That's actually the introduction from the editors, setting out what the book is about. The Roman legal tradition, that is the focus of this volume, developed through centuries of debate, contestation and interaction between magistrates, legislative authorities, legal experts and lay users. So you can see it's built up over a long period of time. Remember, the title is Roman Law and Society, so I think historians will find this fascinating, apart from anybody else involved in legal history. What do we say about the book? Well, we say from Spain's Atlantic coast to Mesopotamia, now called Iraq, and from Scotland to the Sahara, Rome at its zenith occupied and ruled most of the then known world. Its legacy is immense, and its influence on our legal system is, to a significant extent, still with us. Obviously in a more persuasive method as far as we're concerned, certainly in this country apart from Scotland. Published therefore by Oxford University Press, OUP, this book focuses on the Roman legal tradition, a vast area of inquiry comprising a vast range of subject matter brought to light by certainly a vast amount of recent research as undertaken and presented by the book's 50 international contributors from at least 15 countries worldwide. The result is a journey of enlightenment through the multifarious aspects of Roman law, its influence on the prevailing social fabric, and equally importantly, the influence on the social fabric upon it. The three editors, respectively from Edinburgh, Chicago and Helsinki, are careful to note that in ancient Rome, quote, not simply positive law, but also law-making and law-applying institutions evolved in direct response to social and demographic change. And the time frame under scrutiny extends appropriately from the 2nd century BC, that's before Christ, to the 6th century AD, Anno Domini, that's after the birth of Jesus, known as the Long Classical Period. I'm not going to use the newer terminology, I'm using the old terminology here. The focus, say the editors, is threefold. It includes historical inquiries into the autonomy of law, Roman theories of law, and scholarship on the practice of law and the study of ancient societies. And it will be especially interesting, we think, for readers to note the directions in which Roman law developed as Rome changed, not for the better, from a republic to an empire, when, as in the opinion of the editors, the stakeholders, were emperors on the one hand and the jurists and judges on the other, whose commitment to what we call traditions of interpretation as embodied in case law may be understood as seeking to wrest and retain authority independent of the sovereign. And of course that's been the way it's been for a long time. At least that's the theory. More than 2,000 years later, do we not have on both sides of the Atlantic interesting parallels here as expressed by such terms as royal prerogative and executive order? As the debate rages on, we sincerely hope the emperors don't win. And you can see, even in 2017, that the issues are still there. Within this volume, then, it's almost 800 pages long, there's much to contemplate, and that is an understatement, from SPQR in the Roman Republic to legal education, legal writing and legal reasoning, to civil procedure and criminal law and social order. An example there, for instance, is a chapter on repression, resistance, rebellion and slavery, which lamentably was a cornerstone of Rome's economy. At least we've moved away from that. Or have we? Because it's still around in some countries. And it still hasn't been eradicated, that slavery. Hopefully those days are numbered for that particular function. Also notable is the chapter on Roman courts and private arbitration by Leanne Bablitz of the University of British Columbia, UBC, and the strangely topical chapter on urban landlords and tenants by editor Paul Duplessis from the University of Edinburgh, who writes about social housing, tenements in fact built to accommodate waves of immigrants and itinerant visitors who descended on Rome toward the end of the Republic. Legions, you might say, and this is our quote, of fascinating insights are contained in this book, which will be of interest, we think, to historians and academic lawyers, anyone involved in legal history certainly, and all kinds of lawyers for that matter, especially in Scotland, who will appreciate the importance of the study of Roman law as examined from the perspective of recent scholarship. And the publication date is cited as 2016. Let's just have a look at the book again. There it is, at the front. There's the spine, and then there's the back. If I open it in a minute, it's a heavy book. Evidence and Argument, The Truth of Prestige and Its Performance. There we go, give you a standard idea of what the contents are. That's basically a chapter by Elizabeth A. Mayer. So you've got paragraph numbering, you've got the introduction, and you've got running all the way through, and then you do have, of course, some detailed footnotes. Then you've got, for instance, a very interesting point, something I'd be interested in, certainly, page 277, Advocates, and how they did it then. Protagonists must be, or be depicted as, outstandingly prestigious. Well, we certainly are at the bar, is what I would say to that. So I'd like to thank the editors very much indeed for what they've done. Also, I'd like to thank OUP for this series of Oxford Handbooks, which I think are very, very helpful in terms of the high level of content and academic knowledge contained in them. Thank you very much to everybody concerned for producing this excellent book. Bye-bye.